Good afternoon, everyone in the room and those online. It's a pleasure to be here. I'm going to do a little thing off topic before I discuss. Stuart talked about the Fred Hollows Foundation in New Zealand, the initiatives that they were doing to ensure PCI compliance and reduce the risk of attack. Absolutely fantastic stuff. Unfortunately, that happened after the Fred Hollows Foundation in Australia was subject to a significant cybersecurity attack, and all their donors' credit cards were stolen and used. Most were used maliciously. So that kind of stuff shouldn't be happening after an attack has happened. It's far better that it's proactive compliance work. I'm the Managing Director of Stratica. We've been a QSA company since 2009 and a payment forensic investigator since 2011. So it's over 15 years that we've been involved in PCI compliance. We have payment forensic investigators based in Australia and also in Singapore. I'm kind of stuck between glasses and looking here. It's just out of range and it's just too much without my glasses. Excuse me for that. In my session today, I'm going to be talking about a cyber security breach, a ransomware attack, where things went wrong, but they went right as well. But from my perspective as a PFI, there's some valuable lessons that can be learnt from this attack. What I'm going to cover, press my button, right? I'm going to cover what occurred, the actual data breach, the timeline, which was rather drawn out. It was over 10 months after the cyber breach and ransomware demand before we were engaged as PFI to investigate the matter. Way too long. It's very hard to collect forensic evidence when you're called in 10 months after the event. There's some valuable lessons that can be learnt from this case study. It has had to be redacted from the perspective of the names of the companies and various specialist firms that were engaged. I'm also going to, if time allows, talk about cyber insurance, but I can put that slide aside if we want to make up some time. But there's a lesson in relation to cyber insurance and what cover you get. The end of the talk, I've got some very useful links that will give you further information. Okay, this is a bit of a messy slide. There's a lot of stuff there, but I'm going to talk to it. The business that was subject to the ransomware attack was a subsidiary of a major Australian publicly listed company in the medical pathological services. So blood tests, urine tests, COVID tests if you wanted to get out of Australia, those sorts of things, or get into Australia and get out of quarantine. Visitors and Australian residents had to pay for those services using credit cards. The attack happened on the 25th of February 2022. The criminal gang had accessed the business's business and had encrypted all medical data records, which included credit card information within that information. The demand was for $2 million in Bitcoins. Now, ultimately, the ransomware demand was ignored because the company was able to recover and get back into business. Now, when the data breach occurred, unfortunately you don't get the theme from the movie Ghostbusters. I thought people would know the movie Ghostbusters. Who are you going to call? Well, the company called a QSA firm as incident responder. I'm going to call them Ghostbusters for the rest of this talk. It's best that I don't name that firm. They were quite successful as incident responders. Within 24 hours, they were able to get the business back in business and unencrypt. Well, they couldn't unencrypt, but they were able to use backup files to retrieve the medical records of their clients. The incident responders looked at audit files, data logs, and there was only 1 or 2 hours of audit file logs. They effectively had been wiped. That QSA firm formed the view that no credit card data had been taken. I'm not sure how they did that, but they did. The cyber insurer was notified and a law firm engaged. The bank was advised, but no PFI was called in. My understanding is that if there is a possibility that credit card data has been taken or accessed, a PFI should be engaged. Well, that didn't happen. The business got going again and all infected servers were wiped, but no images were kept. However, 3 months later, client data was found on the dark web. Anyway, we're kind of ahead of ourselves on my talk. However, staff were aware that a ransom demand had been made, and I'm going to read it out. During the period your network was under our control, we downloaded a huge volume of information. The information contains a lot of sensitive, private and personal data. Publishing of such data will cause serious consequences and even business disruption. After a payment, you'll get network decryption, full destruction of downloaded data, my emphasis. If you decide not to negotiate, all your information will be posted on our site. The employees, multiple employees had that on their laptops, but unfortunately, people didn't believe them until that data was posted 3 months later. Who found the data? It was found by the Australian Signals, which is a defence department that is looking for nation-state type incidents, not really for stuff related to a medical business. The business was advised. They called back Ghostbusters. Ghostbusters said, no, we don't think any credit card information or customer information's on the dark web, and didn't engage with the Australian Signals Department, which is Australian Signals is part of Department of Defence. The company regarded the incident as resolved, and they just got on with business. Anyway, in June, Australian Signals again contacted the company and said, have a look at this, we've found this evidence. It appears that there's in the order of 2 million customer records that may have been taken, and we have found 30,000 files involving credit cards. The company got back Ghostbusters. Ghostbusters had a look at it, but were unable to retrieve the data from the dark website because, of course, it was there to see. You can't get it back. And then spent the next 4 months trying to work out the information from their own records. The law firm that was engaged some specialists and spent over $1 million trying to sort out and collate information to advise the customers. Anyway, it was only on the 27th of October that the company announced the data breach to the Australian Stock Exchange. The share price halved, brand damage was done, and then on the 10th of November, a payment gateway, I was told to remove the name, but there's the redacted letter up in the corner, advised the company to engage a PFI. It then took 6 weeks of negotiations for Stratica to be engaged as the PFI. Now, why did it take so long? we had to work under legal privilege, which meant we weren't engaged by the firm that had the data breach. Their lawyers engaged us, and we had to work through, make requests for information, and report via the law firm. Why did they do that? So that the reports we did stayed legally privileged and couldn't make it to any possible subsequent court cases. So to this day, my firm has nothing to do with the litigation that's now on foot, but I haven't mentioned that, it comes a bit later. Where are we at? Okay, so I'm halfway through my time, so I've gone a little bit quicker. People don't really want to know about all the details, but there's a series of things that really went wrong that shouldn't have occurred. What did we as a PFI get provided? We got Ghostbusters post-incident review reports. Ghostbusters did not have any logs or analysis that they could make available to us when we asked for copies of the images of the infected servers. There were none, they'd all been wiped. There was no copy of the malicious code still available. There was absolutely nothing for us to investigate. It's kind of pointless engaging a PFI firm 10 months after it's all happened. Was this a cover-up from start to finish? You may be thinking that, but really I think it was a case of people not really understanding their responsibilities when there is a data breach. Ransomware attacks often will involve credit cards. That, in the case of attacks on medical businesses or hospitals, which there's a lot more happening now. Charities, hospitals, this particular pathology laboratory businesses, they spend their money in other areas. If it's a charity, getting more donors, administering programs. Hospitals, they want to look after their patients. They'll spend money on medical equipment, but then less likely to be investing in technology and protecting their customer records. So this is the kind of area that businesses are vulnerable, and the cyber criminals know it too. So was this a cover-up or was it a stuff-up? I call it a stuff-up. The unfortunate thing was that there was no PFI. The incident responders, yes, they did a good job, were able to recover and get the business up and running. However, no one thought to keep any forensic evidence. If we have forensic evidence, and I think there's a couple of PFI firms in the room, they'll do the same thing as us, we share that information with the Australian Federal Police or Europol, and that goes towards getting more intelligence on the criminal gangs that are operating. So, we don't necessarily get feedback on what we've provided to Europol or the AFP, but it helps them in shutting down those gangs ultimately. We learnt a lot about legal privilege. We aren't a law firm. I am legally qualified, but I don't want to call myself a lawyer when it comes to this stuff. But under legal privilege, what you say and write is not available beyond the client. But we were engaged by the client's law firm. So it was regarded and it was checked, the legal privilege held in this instance. Card brands ultimately cleared Stratica to be the QSA for this company because it was only a subsidiary that was subject to the attack, but the issues of PCI compliance were wider and beyond the subsidiary that had the attack. Interestingly, the company was using another QSA firm, not the one that was called in as the incident responder, and they signed off that the wider public company was PCI compliant, including at the time that the ransomware demand had occurred. So I'm not sure how much reliance sometimes can be made on what people within our QSA community are signing and advising clients on. What have I got next? Cyber insurance. I've only got 3 minutes to go, so it will just be a brief coverage of this. When you buy cyber insurance, you've got to look at what you get. You may have cyber insurance that will help you recover after you've had a breach. It may cover getting legal advice. It may cover the cost of a PFI, but not necessarily the ransom payment. You can buy ransomware cover as part of your cyber insurance, but it's an optional extra, and you're going to have to demonstrate a much higher level of cyber security to be able to get it. We actually encourage our clients now to actually seek cyber insurance if they can obtain it. Another lesson learnt that I left from earlier was in relation to paying a ransom. This company thought we don't have to pay the ransom because we've recovered our server information. However, they didn't believe the attackers when they said they had data. They still didn't even believe it when Signals found that data. It would have been a much easier negotiation to have said we have, and they had contact details to the ransom, whatever you want to call the person making the ransom. We've recovered. We don't think your demand of 2 million US, may not be the actual amount, in Bitcoin is reasonable. We're back in business. They will negotiate at a much lower amount to confirm that that data has been wiped. Think about it. Their business model would not last if they didn't honour what they say. I know they're criminals, but their business model relies on doing what they say they're going to do. So there's no legislation in Australia at the moment that says you cannot pay a ransom. So I don't know if regulators are in the room, but I have a view that businesses should be allowed to make that decision. Think about if your son or daughter's kidnapped. You're going to want to pay the ransom to get your child back. Same with the business, the critical customer information. I've covered that point on government ransom. There are ways around ransom payment bans, but don't ask me to talk about that on stage, please. Regulators are far more active in this area. You can't, and I'm sorry I didn't use my little pictures on the side, don't be like the three wise monkeys, hear no evil, see no evil, speak no evil. Don't be like the ostrich and put your head in the sand and think it'll all go away, which is what this company did. And make sure you get your insurance right. I think I've covered the lessons learnt on my way through, and I'm out of time. I'll summarise quickly. A QSA firm as incident responder does not replace the obligation to engage a PFI. I'm not sure how that gets through. The QSAs in this room, there's a number of you here, may well have been the Ghostbusters, or one of them may have been. And similarly, if you're the QSA for a charity or a company and you have a data breach with that client, or they have a data breach, your obligation is to advise them to engage a PFI. You cannot continue in your role. A notifiable data breach, it depends which country you're in, but yeah, there are privacy commissioners, police, other people that should be advised. I'll leave it on Australian Signals. The ransomware gang, engage or not, I say engage, but use a specialist in that area. Don't try and do it all yourself. You may be able to get that through your cyber insurance. Last point, whose role is it to engage a PFI? I don't have the answer on that. A company has to rely on the advice from its advisors. You know, just make sure if you're the QSA in the room or you're involved that you give the correct advice. Sometimes it's appropriate when something like this has happened to just walk away and be honourable in doing that. There's some references there, all quite useful. Visas, what to do if compromised. They make it absolutely clear, engage a PFI. The second one is some stuff from ASD, Australian Signals Directorate. That's more relevant for Australian companies. However, they have some good material there. The last one, the Office of the Australian Information Commissioner. If you want to have a look at that, you'll find some quite interesting stuff. It might even be talking about a prosecution against companies that have had data breaches, because they list them there. The last one, our website, and as I said, we're a PFI, we can service Asia-wide, and we have the other YK, as I call him, based in Singapore, YK Pang. So thank you very much, and I've gone 3 minutes overtime, so I'm probably in a lot of trouble.